So Tom, we're here at your barbecue today. How are you doing?
We are. It's wonderful. I'm really happy and impressed that as many people have come out as they have. We've got some donations and we're all having a wonderful time. There's some great music and some great food. So it's a good time to be together, and we're having some lighthearted discussions and some serious discussions, and just overall it's a very nice experience meeting everybody and looking forward to working together with them.
Awesome. So you wanted to talk about some of the legal bias that you are dealing with in the court system?
Yes. Well, if you listen to the radio show on A Voice for Men that I did on Wednesday, I talk a lot about the legal bias and kind of put out the whole case for it and the evidence of it there. But in my case, what we're trying to do, it's very hard and necessary to get the prejudices and biases of the court shown to itself. This is a factum. Fairly thick document. A lot of work has gone into this. Now here's the situation. The appellate court has to look at this in order to discuss this particular case. And this case deals with 5 errors from the trial judge. One of those errors, and a very important one, is the case for bias and prejudice by the trial justice. We have substantial evidence not only from the trial justice but from the preceding justice during case management. Usually the bar for bias and prejudice is that a reasonable person observing the proceedings and looking at the evidence would consider the decision to be biased and prejudiced. The problem is any single incident by itself usually doesn't stand up. That's why this is so great. On page 12, we point out the very important point. It is submitted by the appellate that the record at trial, taken as a whole, would give a reasonable, impartial observer that there was an element of bias or prejudgment in the trial process. While each example cited below, taken alone, may not be sufficient to meet the test for setting aside a verdict made at trial, it is submitted that the record taken as a whole is sufficient to meet the test for reasonable apprehension of bias. That's absolutely the case. The justice has made consistent errors, always in my ex's favor, always towards the woman, always against me, and often not in the interest of the children. The fact that there were so many errors in this case, so many examples, makes this bias argument very, very winnable, and therefore very, very important. You see, once we get the appellate high court to make a ruling that there has been prejudice and bias by the lower court, every person going into the Court of Queen's Bench now will have a case they can cite as precedent that the Court of Queen's Bench of Canada, and particularly of Edmonton, has issues with bias and prejudice in family law cases involving custody for men, and in particular in cases involving mobility internationally, which is my situation. It's very important that this appeal goes forward. It's very important that this be won. We've put already nearly $65,000 into getting to this point. It was all due to go forward. It was looking very good at the end of April. We were meeting the deadlines. The documents were there, the evidence being collected. Then the other side did something that is a bit of a nasty move, and this was done on purpose to try and get around justice occurring. They made an application for surety. What that means is that they require that a down payment or a deposit be made before the appeal goes forward, based on the idea that, hey, we might lose the appeal and then we'll have to pay costs. So they try to get their money up front. Usually in family law or cases involving important judicial decisions, you don't ask for surety. It's unusual. It's usually only in civil law cases between businesses and where there's a lot of money involved. But they asked for it. We believe very strongly they asked for it because they don't want this appeal to go forward. They don't want it to be heard. They don't want a decision that could be used to help a lot of men get fair custody and access to their children. So they won. They got it. We have to come up with $5,000 by June the 27th for this appeal to go forwards. I tell you, honestly, I was ready to quit. But then some people talked to me and they clarified it. They said, look, $5,000 is only $50 from 100 people. It's only $25 from 200 people. So it can be done. And it's just going to take some work. It's going to take some pulling together. is going to take some collaboration. So at this point, we're already over the $500 mark. Woohoo! A little bit. Still a ways to go. Tiny steps. You know, we've got 5 of those 100 steps. I want to take the next 95 together with you. I want you, to quote Uncle Sam, to step up, step in, and help this appeal happen. Help me, help yourselves, help your children. So go to www.mensrightsedmonton.com. You can read more and get more information there. Click the donate button, donate anything you can. And here's the great thing. If we win the appeal, you may get your money back. So just let us know. If we win the appeal, do you want your money back, or would you like us to use it for the next step? And the next step, ladies and gentlemen, we're going to take a constitutional challenge into the courts of Canada. We're going to have the Attorney General served, we're going to have the Manus Enforcement Program served, and we're going to have a very interesting discussion about enforcements that violate charter rights without due process. That's probably going to take some more donations, folks, but this is the best way to fix the system. Use the system, use its own rules against it, use my case to set the precedent. So let's go. Thank you.